Prior written notice is a requirement included in the federal special education law, which is called the Individuals with Disabilities Education Act, or IDEA. You may also hear prior written notice referred to as a PWN. The prior written notice is a document that must be provided to parents before the district proposes or refuses to take certain actions. First, let's talk about the purpose of a prior written notice. The purpose of a PWN is to let parents have an opportunity to think about the district's decision and decide whether they are in agreement with it. If a family is not in agreement with the decision, they have an opportunity to use their dispute resolution options. The prior written notice provides families with all the information that led to the district's decision. It's important to note that the law does allow for districts to include the PWN in the IEP rather than on a separate form. In Colorado, schools use a form to serve as their prior written notice called the Prior Written Notice of a Special Education Action. This form contains all of the required pieces required by the procedural safeguards. Let's review each one. First is a description of the action the school district is proposing or refusing to take. This should be a clear and understandable description of the decision made by the IEP team. For instance, it could be something like, "We are proposing to conduct a comprehensive initial evaluation to determine eligibility for special education services." The prior written notice also needs to include an explanation of why the district is proposing or refusing to take the action. It must include all of the data the district used to support their decision. This could be the results of a recent evaluation, classroom assessment data, or any other relevant information included in the decision-making. The PWN has to inform parents that they have the rights included in the procedural safeguards and provide instructions and contact information for where parents can get help understanding the rights. The notice must include other options the IEP team considered before making the final decision and why those options were not chosen. Finally, the notice must also include a description of any other factors relevant to the proposal or refusal. The district has to provide this notice in a language that is understandable to the general public, and it has to be provided in a parent's native language or other mode of communication unless it's not feasible. Colorado's procedural safeguards define native language as the language the parents normally use. For parents who do not use a written language, the district must have the notice translated orally and ensure that the family understands it fully. Districts are allowed to send certain documents to parents by email if the family chooses that option. A prior written notice, the procedural safeguards notice, and documents related to a due process complaint can all be sent via email. The last question to cover is, when do districts have to provide a prior written notice? A district has to provide a PWN whenever it proposes or refuses to begin a process or make a change to the identification, evaluation, educational placement of your child, or the provision of a free appropriate public education to your child.